Hello, bonjour, and welcome to this noon hour webinar on careers in international trade law. My name is Chris Waters, and I have the pleasure of moderating this careers panel together with Hannah Diebold. It's the second in a series on careers in international law that we're planning. You can find a recording of the first one on careers in international law generally on the website of the International Law Association, Canadian branch. In a time of disruption in international legal order, not least in the international trading system, we need good people taking up this work and not letting crises go to waste. So thank you for joining us and thank you for your interest in this area. Bienvenue au webinaire d'aujourd'hui que j'ai le plaisir d'animer avec ma collègue du Conseil de l'administration de la section canadienne de l'Association de droit international, Hannah Diebold. Hannah est avocate associée chez Blaney McMurtry à Toronto et je suis professeur à la faculté de droit de l'Université de Windsor. Cette séance se déroulera principalement en anglais, mais vous êtes invités à poser vos questions en anglais ou en français. Et je note également que nous prévoyons un webinaire dans cette série qui se déroulera en français. We're meeting virtually across Canada on Indigenous territories, and I note the importance of bringing Indigenous goals and concerns into any trade agenda, including in light of UNDRIP Article 36, which provides that Indigenous peoples, in particular those divided by international borders, have the right to maintain and develop contacts, relations, and cooperation, including activities for spiritual, cultural, political, economic, and social purposes with their own members, as well as other peoples across borders. The ILA of Canada is the Canadian branch of the International Law Association, based in London, England, and founded in Brussels, Belgium in 1873. With nearly 5,000 members worldwide, our collective objective is to promote the study, clarification, and development of international law, both public and private, and the furtherance of international understanding and respect for international law. Our membership is global and diverse, and our members provide a full range of international law services to states and non-state actors that shape our current socioeconomic, environmental, and political context. Comprised of legal scholars, legal practitioners, such as our guest today, students and policymakers, the ILA Global Network and its regional and national branches contribute to the work of ILA research committees on important topics of international law. And the ILA organizes panels and workshops on a wide range of international law topics, such as this one on international law trade practice. I invite you to visit our website, and join ILA Canada. Membership is free for students, and I know many of you are on the call are students today, so I encourage you to take that up. Renew and replenish our valuable global network of international lawyers. So thanks again for joining us. And you're invited to put your questions in the Zoom Q&A function. And again, please feel free to pose your questions in English or French, and I will do a quick translation. Okay, with that, I will turn it over to Hannah. Thank you.
Thanks, Chris. We have a truly esteemed panel of speakers today that I have the pleasure of introducing. Valerie Hughes spent 22 years with the Government of Canada, holding senior positions with Global Affairs Canada, Finance Canada, and Justice Canada. She has done extensive work with NAFTA, the Canada-United States-Mexico Agreement, and WTO panels. She taught international trade law at Queen's University and has published extensively on WTO law and dispute settlement. Valerie is currently serving on 2 binational panels addressing trade remedies disputes under the Canada-United States-Mexico Agreement. Welcome, Valerie. John Boscariol is a partner at McCarthy Tétrault and co-head of their International Trade and Investment Law Group. John has taught at the University of Western Ontario and was recognized as Lexology's sole Canadian global elite thought leader in international sanctions, a global elite thought leader in the area of trade and customs, and as Best Lawyers 2026 International Trade and Finance Law Lawyer of the Year. Congrats, John. Anumeet Toor focuses on international trade compliance and optimizing global trade and transportation practices. Anu has experience advising on CBSA audits and appeals and representing clients at the Canadian International Trade Tribunal. Anu has received several distinctions, including the King Charles III Coronation Medal, the J.W. Whiteside Award, and participation as a member of the Young Diplomats of Canada at the 2018 IMF and World Bank annual meeting. Thanks for joining us, Anu. So the structure of today's webinar is as follows. We're going to have some structured questions first, and then as Chris mentioned, we'll move on to Q&A questions at the end. So to move on to our first question here, what does your work look like on a typical day And does that question even make sense anymore, given challenges to the rule of law and international trade law, including around dispute resolution? Let's start off with you first, Valerie.
Well, thank you for the invitation. This is a real delight to be here, because if there's ever a time to be talking about careers in international trade law, it's now. It's a very interesting time for those of us in the field. In terms of a typical day, I was advertised as a person who's doing trade dispute arbitrations right now. That's what I do now. I'm not working in a law firm anymore, or doing the WTO, but I thought it would be better to talk about my time as an international civil servant at the WTO, because that would be more interesting, I think, for those listening. So the typical day, if there ever was such a thing for a WTO person, the World Trade Organization in Geneva, I worked there in two legal divisions. One was the appellate body secretariat, which assisted appellate body members in deciding WTO disputes on appeal. And then I worked as head of the legal affairs division. So they assist adjudicators, first level adjudicators, panelists, they call them at the WTO, in deciding trade disputes, and also act as legal advisors to the institution itself. So what's a typical day of somebody in that role? You might be, say, assisting panelists in adjudicating disputes. Well, what does that mean? You may be asked to provide advice on the rules of procedure. You know, what happens if you file a submission too late, or what happens if during a hearing somebody wants to go beyond the time allocated for speaking, or what happens, you know, if you have somebody who's alleged not to represent the government, like, for example, with Venezuela in a dispute. So things like that. You have immediate sort of requests for rules of procedure advice. You also assist these panelists to decide, because they are part-time people. They're not people that are everyday judges or everyday sitting in dispute settlement. They are ambassadors, they're professors, they're negotiators, they're all kinds of different people that are doing this on a part-time basis. So you need to assist by preparing research papers, what the law is on this particular issue, on the issues in dispute. What has the appellate body said before? What have other panels said before about those issues? So you prepare those research papers so that the panelists can obviously be well informed coming in. You help them prepare their questions for the hearing, because they can pose questions during the hearing, and you help them prepare the questions because obviously after reading the submissions, there are different points of view on issues and you'll want to explore further. You might draft procedural aspects of the award itself, the ruling itself, depending on what panelist wants you to do. So that's how you assist a panelist in adjudicating disputes. That's one of the things that you do. There are other tasks, but I know other people want to speak. I'll just name them. You can assist delegates with dispute settlement matters, like choosing panelists. You can assist the chairperson of the dispute settlement body, a meeting every month of all WTO members of the dispute settlement body. And there might be a motion raised on the floor objecting to something, and you have to give your advice then. What are the procedural rules about that motion? And you also provide legal advice to the Director General on things like how to implement a new agreement under the WTO, or give a view on what is the legal value of a WTO committee decision for purposes of dispute settlement. So those are the kinds of things you might do working at the WTO.
Amazing. Thank you so much, Valerie. John, we're going to come to you next.
Sure. Thanks, Hannah. And again, thank you everyone for involving me in this panel. It's great to be on here with Anu and Val. As Hannah mentioned, I work at McCarthy Tétrault, a full-service law firm here based in Toronto, but we've got offices across the country as well as New York and UK. And my area is international trade and investment law, and that involves customs duties, anti-dumping, countervailing duties and actions. It involves interpreting international trade and investment agreements, bilateral investment treaties, economic sanctions, export controls, anti-corruption, supply chain laws like forced labor, child labor laws, and so forth. So I'm going to date myself, but just to put some perspective on it, when I started practicing in the late 1900s, sounds pretty old, but it was 1995. I first became a lawyer, and at that time, we had just brought Mexico into the free trade fold, so we had just negotiated NAFTA. We had negotiated the agreements of the World Trade Organization. It was a very, very exciting time for trade lawyers because we were able to go to clients and say, look at all these international trade agreements, look at the opportunities they have for you in opening up these markets. And what we saw happen over time was customs duties went down. It became less relevant to the practice. Anti-dumping and countervailing duties obviously stuck around and have been used, continue to be used quite aggressively. But we also saw the rise of export controls and the use of economic sanctions and anti-terrorism measures. And it's been a trend, I'd say, in particular, for the last 10 years or so, where I would argue it started even before Trump's second administration, where we've seen a deterioration in the rule of law when it comes to international trade, and at the same time, this rise in use of economic weapons. And when I'm referring to economic weapons, I'm referring to economic sanctions, anti-terrorism measures, export controls, tariff measures now, particularly as used by the Trump administration. But Canada is just as guilty as you saw with the imposition of 100% tariffs against electric vehicles from China. Countries now are equating national security with economic security. And that was not a thing when I started practicing in the mid-1990s. In fact, we all focused on the very narrow nature of measures taken by countries to protect their essential security interests. There were narrow exceptions in trade agreements for that. Now it feels like trade agreements don't matter much anymore. The agreements of the WTO don't seem to matter much anymore. And it's kind of in this environment now that trade has exploded. The trade practice, I should say, has exploded as countries are now relying on these various economic measures or weapons without really paying attention to the disciplines that are imposed by international trade agreements. So, you ask about what a day is like of an international trade lawyer. At least for us, it feels quite chaotic. It's hard to kind of predict, what's going to happen when you come into the office any given day, particularly with the administration that's in place south of the border. Last year, at this time, it was just before Trump implemented IEEPA tariffs against its most, the US's most important trading partners. We would have been surprised had we known what was coming at that time. Even in January of last year, we had Trump threatening it, but I think we would have been shocked to learn just how far he went with these trade measures. And so I do think, when we think about our typical day here, no 2 days are the same. It feels sometimes very reactionary that clients want to speak immediately given an announcement from the Trump administration. So, we have to be very flexible on that. And it's hard to predict. And, there's advantages and disadvantages to that. What I would say for those of you that are just starting out, looking at careers in this area, particularly those of you kind of in your 20s now, your late 20s, early 30s, you're in the millennial generation. You're the generation that's going to take us through this crisis period. This is very similar to the time, I think, pre-World War II. Not that I think we're going to necessarily end up with any world wars, but you look at that period leading up to World War II, where we had the US imposing 20% tariffs across the board under Smoot-Hawley. You had countries becoming very inward, the rise of nationalism. A lot of that is repeating today. History moves in cycles, and we're in that cycle now. That cycle back then was ultimately resolved, and you saw what we refer to now as the greatest generation, putting in place these great institutions, GATT, the IMF, UN got strengthened. All of that was built post-World War II. You're going to be the ones, the millennial generation, and maybe even parts of Gen Z are going to be the ones that build that when we come out of this crisis. And you're going to be building the new institutions. And I do think in the next 5 to 10 years, we're going to see these, the old institutions we relied on and got used to working with as lawyers. I'm in Gen X, so the old institutions Gen X was dealing with are going to be replaced by something different. And so it's really exciting to be in your position, I think, now looking at this and experiencing this and contemplating careers in this area. So I hope that, Hannah, that answers that question about a typical day. There isn't really a typical day, it feels like, in this area for us.
Certainly, John. And yeah, thank you so much for kind of giving us insight into what the field generally looks like now. And Anu, on to you.
Hi, so thank you again for having me. My name is Anumeet Toor, and I work at Root Transport and Trade Law. So part of my practice focuses on trade law. It's a passion of mine, something I'm very interested in. I also dabble in transportation law, which goes hand in hand because oftentimes when there's a transportation issue, you also have a trade law issue. And to kind of piggyback off of what John said, and Valerie, thank you for that the overview of your experience at the WTO. That was really wonderful to hear. But to piggyback off what John said earlier, is that things change so rapidly that the day-to-day often is unpredictable. I typically, in terms of time management, I try to have a schedule of what I hope to achieve in a day, set out 1 or 2 days in advance, if at the least. But lately, with upcoming changes, it's absolutely right that clients are searching for answers sooner rather than later, particularly when there's a given update. One of the things I actually do is I actually rely on resources. And funny enough, I rely on John as a resource because John is excellent at updating his Twitter account or his LinkedIn account with the most relevant and recent news. And a resource like that becomes very, very helpful for someone like myself to get timely and contemporaneous updates. So I think in terms of a typical day, as a trade lawyer in 2026, the first thing you really have to do is you have to start by getting your ducks in a row and looking at all the updates that have happened overnight sometimes that you haven't really even begin to review or go through. And so I think that's always the starting point of any given day is to figure out, hey, what's going on? After that, it's also a lot of my day and a lot of my time I've found has been attributed to corresponding with clients and communicating with clients. And these are some, and almost it gets to the point with how do you even explain these changes or the rationale to clients? Because sometimes things are so silly or so insane and out of pocket, unpredictable, that even corresponding or explaining things to your clients becomes a part of the challenge. And so I think in terms of a typical day of a trade lawyer in 2026, those are some of the starting points of doing your research, getting your ducks in a row, figuring out what's going on, and then translating that information and making it digestible to your clients. And so it's a 2-factor situation where you do your research and then you distill it so that it's absorbable by your client base. And then the rest of it is a pretty typical day for a lawyer where you have different client meetings and different client memos that distill down. And in terms of what John said, my career began in 2018 where things were pretty tame. And I recall in Canada, we had Magnitsky legislation, which was made in honor of Sergei Magnitsky, and those were designed to act as a shield. But what we've seen now is that these sort of laws and legislations have absolutely become a sword to use against other countries, which is deeply unfortunate. Economic sanctions were a wonderful tool to ensure compliance with global order, but what we're seeing now is more chaos and more havoc. And so it's a bit of an unfortunate turnaround to see tools being used in such a way. And so that is definitely a bit of a jumble that we're facing in 2026, and it does impact our day-to-day. But again, just one day at a time, because who knows, it's something may be in place tomorrow, but 3 days later it may go away, and we never really know what to expect.
Yeah, it's easy to appreciate that what was once an area that focused heavily on what the rules are and what the law is, as mentioned by Valerie, continues to change overnight and, is now an industry or a field where the rules or lack thereof have become weapons, as mentioned by you, Anu, and John as well. So thank you very much for your responses on that. Moving on to the second question. What is a thorny issue you are addressing in your work right now? And how did your experiences to date help prepare you to tackle this issue? John, I think we'll start with you on this one.
Yeah, there's a number of thorny issues, but I want to use one in particular as an example, and it kind of picks up on what Anu was saying about the use of economic sanctions. When Russia invaded Ukraine for a second time in 2022, and the world, or at least Western powers, responded with economic sanctions, that was the most impactful economic sanctions program, I think, in our modern history. Not because we did to Russia what we've done to other countries like Iran and North Korea, where we really did isolate them with our sanctions measures. Russia is not fully isolated as a result of sanctions. But it was the most impactful because we targeted a country that was fully integrated into the world trading system, fully integrated into the international financial system. And so Canadian banks were dealing with Russian banks, even though there wasn't a huge amount of trade between Canada and Russia. If you were a Canadian company or Canadian financial institution doing business internationally, you would run into Russian-owned businesses. You'd run into businesses owned by oligarchs who are now sanctioned. You would be dealing with Russian banks, most of which are all sanctioned or listed. So it was a hugely impactful sanctions program for the Canadian business community. And the challenge for us as lawyers is Canada is in many ways, when it comes to sanctions, more of a sanctions hawk than the United States and other countries. Not necessarily with public enforcement of those sanctions, but in terms of how they drafted the measures. They are drafted very broadly. And Canada, although just recently in the last few months has done a better job of issuing sanctions guidance, really for the most part hasn't yet fully supported Canadian businesses, I would say, with appropriate guidance like you might see in the United Kingdom, the EU, or the United States. We still have a ways to go. I think they're making improvements, but part of the reason for all of this was Canada reacted very quickly, as it should have, to the Russian invasion. We imposed very onerous sanctions measures, more onerous than other Western countries, and we did it under very broad terms and without guidance for our company. So as a practitioner, this presented a pretty unique dilemma, I would say, where we have no case laws. There's no jurisprudence on these measures, or very limited jurisprudence. We have no guidance from the government, but you have companies and clients that are asking for immediate answers to questions about whether something they're doing in another country violates Canadian sanctions. And the questions can be pretty complex, many of them never considered before by the government policymakers. Frankly, and historically, I would say the Canadian government has understaffed the sanctions function administratively within Global Affairs Canada. So it was it's an exciting, fascinating issue to deal with, but very tricky. And it made it even more challenging because when your client, who has operations around the world, goes to counsel in the United States, the UK, and the EU, they had very clear guidance on a lot of these issues. And they could give a very clear answer. And we'd be here in Canada saying, well, the Canadian government hasn't offered any guidance on that. And based on, we can give you our best view on the interpretation of the words in the Canadian legislation, but there's going to be a lot more uncertainty on the Canadian side. So dealing with that is a really thorny issue. It makes the practice, I would say, exciting but challenging. And in terms of what I'm not sure there was anything that really helped prepare for that. Certainly having a basic grounding in principles of statutory interpretation is important. That comes into play a lot. Having an understanding of working with government and being able to look at some of these issues from the policy side is very helpful in those circumstances. But it's Global Affairs Canada has, in the last 12 months, I'd say, really tried to step up and improve that situation. They've created a sanctions bureau to deal with it. They've hired dozens into that sanctions bureau. They're reorganizing a bit to be a bit more responsive to the business community here in Canada on these issues, but still a problem we're struggling with.
Unlike other areas of law where we can kind of watch it come down the pipeline, as you mentioned, trade is so reactionary sometimes
That's right.
Where you have to make the changes that occurred, as discussed in the first question, even overnight.
And Russia, I think, was really a rehearsal for what's going to happen with China. I think we will start. China's going to make some move against Taiwan. They're going to continue human rights violations in the Xinjiang region. They're going to continue to assist Russia and North Korea in evading sanctions. One or all three of those in combination are going to trigger more sanctions. We have some sanctions against China now, but they're going to trigger more sanctions. And putting a Russian bank on a sanctions list was complicated for Canadian business. You can imagine putting Chinese banks on sanctions lists, given how much more business we do with China and Chinese banks, how complicated that's going to be. So watch for that in the future.
Much more work for everyone in the field to come then, for sure.
Yeah.
Thanks so much, John. Anu, on to you.
I think just carrying on that conversation, in terms of a thorny issue that I've personally experienced when dealing with my clients is compliance fatigue. And so what we're seeing is that these changes are so rapid and so ever-changing and over such a long period of time now that going back to your clients and trying to explain to them the different criteria, and it's exactly what John was saying earlier in terms of not really knowing how to meet these standards because there is no precedent for this, but trying your best and trying to get your clients in compliance. At a certain point, a fatigue sets in, and we're at that point with the clients where it's at the point where if you're calling them to communicate, you almost become, it's almost a situation of don't shoot the messenger. And so the way I counter that is I try and make it a little bit friendlier. I don't always start my conversation straight down to brass tacks. I kind of try and say, well, hey, how was your weekend? And spending maybe a minute of the conversation warming the person up to receive more news and more work that they have to do, more money. It's obviously, compliance is expensive. It's something that you have to integrate into your procedures. It's something that you have to train your staff on. And so it's never good news to have to distill that information, but just taking a moment to remember that your client also is a human, taking a second just to chat with them about how their day is or how their weekend was, and then distilling the information to them, it shows them that you're on their side and that you're on their team, and it kind of takes away the harshness of the message. And so I would say it's compliance fatigue, and that's how I combat that with my clientele. And I think that's a good thing for especially junior lawyers, to keep in their back pocket. It's just, if you have bad news, take a minute to take a breather before you deliver it.
Thanks so much, Anu. And Valerie?
Let me just follow on with the kinds of things that John and Anu were addressing by talking about something called the security exception in something I had to deal with as a legal advisor and an arbitrator. What happens in the WTO is there are a number of exceptions that allow you to not comply with your trade obligations if you meet certain conditions under an exception. And the security exception is Article 21, and it's been in place since 1947, since the original GATT. And what that exception says is that a WTO member, can take any action that it considers necessary to protect its essential security interests. The issue, though, was that this exception hadn't really been relied upon, even though it existed back in 1947, all through the GATT years and through the early years of the WTO. No one really relied on it, and there was no real interpretation of this security exception. How does it work? How do you use it? The issue came up with the United States using the security exception to justify their in Trump 1 administration, their imposition of steel tariffs in a discriminatory way. So what happened was the United States used this provision and said that once a member of the WTO says we're working with the security exception, the panel has no role. It's self-judging. So you cannot look and see whether or not we are using this properly, because it's our security interests we decide. You can't have a panel decide what the security interests of a nation are. So the question was how to deal with this, because the United States was already very, very unhappy with how certain things were going in the WTO. How do you advise a panelist, and how, as a panelist myself dealing with this, do you write this ruling so that you can interpret the use of the security exception in a way that does not blow up the WTO for its utility going forward? And what happened was, with the way my panel settled, it was between UAE and Qatar, but not USA, but it was the same issue. And my panel settled before the ruling was issued. But what happens is that the United States, when the ruling came out that it isn't self-judging and you have to meet the rules of how this provision is drafted, they said, well, then we're not going to comply with the ruling. Now, this was in, I think, around 2019, and from 1995 to 2019, not one single WTO member said we wouldn't comply. Everybody might have taken a while to comply. It might have been a little bit slow to comply, but no one ever said we're not going to comply. And that was a major issue, how to deal with this security exception, how to use the Vienna Convention on the Law of Treaties to interpret it, bearing in mind the political consequences. So that was a tricky issue. And I'll just to use something a little bit different, the other kinds of political issues that get in the way when I was at the WTO is you can't use the name Taiwan for the separate customs territory of Taiwan, Pengu, Kinmen, and Matsu, which is the formal name. But you can't use the word Taiwan. You can't use Macedonia. Greece objected to that. Of course, China objected to the use of Taiwan. And so these kinds of politically infused legal issues, and how do you advise the Director General? These are things that come up from time to time. So what experience helped me tackle these kinds of issues? I have to say it was because I spent a lot of time working in the government. And I understood that as a lawyer in the government, you have, of course, a duty to provide legal advice as best you can. But there is also the political advice that's going to be beside it. And that's not your role, that's somebody else's role. And to understand that both of those things are going to be informing the decision maker.
Common theme so far, certainly throughout the webinar, is that experience working with government is a huge advantage in this field for sure. Alrighty, so moving on to our next question. We might have already touched on certain parts of this with our previous question, but what do you like most and least about your job? So Anu, I'm going to start with you on this one.
Thank you. And Valerie, every time you speak, I'm absolutely enthralled with your experience. And so thank you. In terms of what I really enjoy about my job is that I do think that the fact patterns, believe it or not, are deeply and wildly interesting. I think that might be a me thing. I really love trade law. I'm a big trade law nerd, but I do think, for example, everything Valerie just said was enthralling, and I find that to be very exciting. I think that's something people take for granted. Trade law is really, really exciting. And believe it or not, there are so many interesting fact patterns that come before my desk. And I think it's just such a wonderful area of law in that regard. If I had to speak about something that is not the best, some things do take quite a lot of time. And so more internally within Canada, when we go through the different court systems, sometimes it can take quite a lot of time to get to your end result or desired conclusion. And, it can get frustrating for clients as well, particularly when you have to convey to them that things are being delayed or held up for various reasons. And so, but I think that's typical for any legal job across the board. But if I had to say something that I personally like the least, it would just be how long a file can take to close out. But other than that, no complaints. I love what I do.
Amazing, thank you. And Valerie, to you next.
It's wonderful to hear that, because a lot of people are saying, the trade law, I had a student speaking to me last week asking me about career advice and saying, well, really, should I go into this field? Because trade law is, what does it mean? It's not useful anymore because the rules don't matter. It's fantastic that Anu, is just emphasizing how much the rules do matter, and you do have to understand those rules in order to be a good trade lawyer. I would say, though, the best part about my work at the WTO was the fact that I work with people from everywhere. Right? There are people that come from a variety of different countries and cities, and so you learn about them personally and what's interesting about their cultures. But what's also interesting is the different ways of approaching law, different areas of law. So I learned rather quickly that the North American, I'd say, approach to conflict of interest was different from the European approach to conflict of interest. It's a bit looser, at least in my experience, in Europe than it was, that we're a bit stricter in North America. That was, one of sort of the legal cultures. And also just the way people present arguments in a dispute. A much more demonstrative, I found, from the North Americans than certainly the Asians. And just, watching this unfold before me to see how people do things differently and learning from each of them. And so when you're appearing before a panelist who's used to the sort of the demonstrable big picture, showing things on a big whiteboard, etc., that works with some arbitrators, and it might be a bit daunting for others. And so these are lessons I learned. And I remember in a hearing about the European Union banned the import of seal products from Canada, and there were videos playing of the seal hunt, which, as you can imagine, were disturbing, and they were playing for a long, long time. And I was in the hearing room observing, of course, and one of the delegates, came to me and said, "You got to get them to stop showing this video." Of course, I couldn't do that. They would have to approach the chair for that. But in any event, these are the kinds of things that, came to me when I was doing work in an international organization. You just have exposure to all kinds of different things. The worst part, I think, is, of course, the management issues of trying to get enough budget and enough personnel and enough, promotions for your people. All of those management issues were for me, the hardest part, because it was just hard to do, and struggling to get enough budget is not easy. And then, of course, for non-management, it's the deadlines, the heavy workload. That treaty says you have to have it filed by tomorrow. You can't just say, well, by the way, I need another week.
Now, it seems like there's lots of work in the field. So I'm curious, do you think budgets are going to soon expand to account for more rules?
In terms of the budget at the WTO?
Yeah.
Yeah, well, the trouble was that the United States decided not to pay its annual dues. And the way that the WTO is funded is by every member that pays their annual dues. The United States, China, they're some of the biggest ones because it's based on the size of your economy. And so the internship program stopped because there wasn't the funding to do it. This is, the Canadian government, along with many other WTO members, funds something called the Advisory Center on WTO Law, which is like a legal aid group that helps developing countries argue cases or advance in negotiations their positions. And the United States is not a member of that. They don't contribute the funding to that because they know that they're often on the other end of disputes, so they don't want to feed to that. So it's not just a question of whether or not there's enough available. There's some political decision-making that comes into those budget decisions, which is frustrating for someone who, simply wants to get the job done. And the United States has now paid their arrears for 2025, and we'll see what happens this year. But these are the things that are making the budget decisions, not, and as governments over certain periods were reducing their, they had to reduce and look at Canada, it's going to be reducing its size of the government. Does it want to have to pay more to staff up more at the WTO when its own requirements are to, make it a more lean government? It's not easy.
Can imagine. So thank you, Valerie. And John, on to you.
I'm going to start with what I like least and then get to what I like most. I think least I've got 6 kids, and having a family is pretty important to me, obviously, and that's a really difficult balance in this job, and particularly in recent years, but I'd say even when I started in the 1990s, when we were doing a lot of anti-dumping and countervailing cases during that time, there's a huge amount of them for steel and other products. You need to really work up a very steep learning curve on this, and it's best worked up at least when I went to law school, they didn't have many courses on international trade law. I went to U of T, we had one course taught by Bill Graham, which largely focused on GATT law. So a lot of the learning for international trade law came in practice. And it takes a lot of time away from family. And I think the way the practice has evolved, especially within the last couple of years, at least working in a law firm, clients come to you when there's an urgent issue. If the issue isn't urgent, sometimes they can figure it out on their own, or they'll wait until it's urgent. And so no longer can you wait a couple days to answer. It's typically they're paying law firm fees. The expectation is that you need to respond immediately. And maybe that's a pressure we all face as practicing lawyers, but it feels like it's gotten particularly intense in the last few years, and requires you to carefully balance, I think, the rest of your life with your practice. And sometimes, looking back, I question whether I had that balance right. On the other hand, in terms of the best things about this job, first of all, I was a trade geek, like Anu. I was also very interested in how products are made. And if you do an anti-dumping and countervailing case, and you tour facilities where your clients are making products, it's fascinating. And we did cases on bacteriological culture media, on dishwashers and dryers, and you get to see how these things are made, and it's not just pure law you're arguing. So that was particularly fascinating. And I think now with a large part of the focus of my practice is on economic sanctions, anti-terrorism, export controls. A lot of those issues are, they're hitting the media headlines on a daily basis. And these are fascinating issues to deal with. They're issues that haven't really been dealt with before, as we were alluding to earlier. And that makes, I think, the practice really exciting, and one that I feel grateful and privileged to have been a part of.
Certainly, and I would imagine that that's a shared sentiment among everybody here and all of our attendees. So thank you. Just briefly here, our last question is, any advice for student or early career practitioners just starting out? Now, in the hopes of getting in some of our Q&A questions at the end, I ask that you just keep it to one piece of advice. But Valerie, we're going to start with you.
I think that you need to be a good writer. If you have the best legal argument, if you can't express it well in writing, it doesn't do you any good at all. So if you aren't good at writing, or if you haven't done a lot of essay writing in your undergraduate degree, or if English is not your first language and you're going to be working in English, take a course, study, learn how to write well. It will be an invaluable tool. in any legal work you do.
Thanks so much, Valerie. John?
I from my experience, as I mentioned earlier, there weren't a lot of courses you could take on trade law. I still don't think there are a few in law school, but not as many as there probably should be. So really be open to taking the time to get the experience in your practice. And so I know that's going to be challenging for some if you're in a larger law firm. I think taking on those tasks involving international trade files, understanding when you do that, as I said before, it's a really steep learning curve for this area. But the time you spend on those in your early years, at least from my experience, it really pays off later on. So try and get that experience as early on as possible in the legal environment you're working in after graduation.
Perfect. Thanks, John. And Anu?
In terms of really, really practical, concrete advice that we can address today, if you're under the age of 30, there's a group that I was a part of that I took advantage of called the Young Diplomats of Canada. And so I was able to join them and attend as a Canadian advocate the International Monetary Fund and World Bank meetings. And so that was a structured way for me to develop advocacy skills and get my boots on the ground. And so that's the Young Diplomats of Canada. There's also, if you're interested, the Global Shapers Foundation, which is through the World Economic Fund. So that is another great organization. And then the third and final piece, obviously, if you're a student in particular, would be to join ILAC and to network with individuals who are a part of the group. And those are really concrete, practical things that students can do just to get their name out there and just to get to know people who are in the industry and to, like, for example, Valerie and John are both careers that I have actually followed. And so just really learning what people do and then being able to apply yourself to the same standards.
Amazing. Thanks, Anu. I'm hoping everybody was scribbling all those names of the organizations down as you were saying them. That's wonderful. Alrighty, I'm going to turn it over to you, Chris, for any questions that arose in the Q&A.
Thanks very much, Hannah. So we've got a couple of questions, and folks who are watching the webinar, feel free to add your additional questions. And if we don't get enough time to answer them all, I'll do my best to crib some notes from our speakers and send them on. So feel free to post them in. So the first one is from Lucia, who asks, what are the most common entry-level or early career roles for someone with an international legal background and a Canadian LLM who's interested in international trade law, particularly outside of traditional firm practice? And what experience tends to matter most when breaking into trade law roles in Canada? And is the focus more on litigation-oriented trade lawyers or compliance and advisory? So I think there's probably two questions there. The first is, any advice for internationally trained lawyers with some Canadian education or experience? How do you break in? And does it tend to be litigation or compliance and advisory oriented? So feel free to answer one or both those questions, and I'll start with you, Valerie.
Yeah, of course, it obviously depends on what you want to do. The working in a Canadian law firm versus working in an international organization or working in a law firm, say in Washington or London. I mean, there are different, I think, different requirements in my experience from or even working in the Canadian government. So my sense is that if you've got an international law background, that's how I got into trade. I didn't start that way. I understood the Vienna Convention on the Law of Treaties and had been involved in international disputes that Canada was involved in at the ICJ. For me, it was just the practical experience that I'd had doing dispute settlement, and I knew that area better than a lot of people because Canada didn't have a lot of international dispute settlement experience. So it's hands-on experience. So if you work as a summer student in a law firm in a litigation function, I mean, that's going to teach you, deadlines and rules of procedure and things like that you can, feed into a practice, I think, in a law firm. But if you are interested more in sort of an international kind of organization like the WTO, you need less sort of the practical, I think, and more the technical knowledge, I think, it's just the way it's, whether that's right or wrong, that is actually how it worked. And if you want to apply for an international job, I think, when we put out a job poster at the WTO, we would get 4,000 applications. So if you have to make your way through those 4,000, of course, 2,000 are not going to be valid at all, but you'll have to do something different. So did you work abroad doing something in an international human rights place, or did you work at in South Africa learning how to help, constitutional change? Did you work someplace where, water management was an issue? These are things that are going to distinguish you from the other 2,000 that are looking at. So I think it's do something different. Make sure you get off your street that you were born on, and bring something that's going to distinguish you.
Thanks, Valerie. John?
Yeah, I want to focus on the part of the question about what experience tends to matter most in terms of litigation oriented versus compliance and advisory. That's an interesting point. We evolved here, our group within McCarthy's started in tax, of all places, largely because of indirect tax and customs duties. And in the 1990s, that was really trade law was focused on tax, was focused on duties, anti-dumping and countervail, as well as customs duties. And we soon after that moved to litigation because of the advocacy elements of trade law, which we thought were pretty critical. We've since moved into business law, but I think over time, advocacy is certainly critical, but over time, regulatory compliance has just exploded in Canada in terms of being part of the trade practice. So advising on compliance with sanctions, I mentioned anti-terrorism measures. And then because of the way those measures are structured in Canada as largely being criminal, we usually have our white collar defense folks that might be involved in that as well, although Canada has a limited track record of public white collar enforcement when it comes to these measures, although those are the primary mechanisms. So I would say it's kind of evolved over time. I would always tell students that a grounding in administrative law was critical for this area, particularly if you're going to be dealing with the Canadian International Trade Tribunal and the Canada Border Services Agency that Anu was mentioning in terms of her experience. Understanding administrative law, and I didn't take a lot of courses in that in law school. I really had to learn that on the go, but that was really critical to that. And then nowadays, as we're expanding and regulatory compliance has become critical, and these are issues that are discussed at board levels and senior management levels within organizations, being able to deal with those issues are just as important. So it really is a mix. I think of those things that we'd be looking at in terms of, if an experienced lawyer was to apply here.
And Anu?
I think I was called to the bar. I started my career in 2018, called to the bar a year later. And I think a lot of my learning, what I want to emphasize is it happened in real time while I was working. And so your law school education is wonderful and it's a great basis, but the practical skills that you learn by diving into this work is really where you gain your practical experience. And because it's so rapidly changing, it's those days that you spend applying yourself and learning from senior lawyers and actually doing the work that gives you the ability and confidence to move forward in your career. I remember myself perhaps 5 years ago, and I was so nervous, and now I'm a lot more confident in the work that I do. And so that growth and evolution was really gained by myself through the work that I did. And so I say network, don't be shy, reach out to people who you want to work with and chat with them. And you never know, one day they may have an availability for you in their office. Build a network of people who inspire you and who you can see yourself working alongside. And you never know when they may reach out to you for help with their work. And so once you have your foot in the door, once you're working, the best way to learn is through experience and applying yourself and really absorbing as much as you can. And so I'd say that's my tidbit.
We have a question from Tim who asks, have you noticed any impacts from AI adoption in your respective practices or the trade law field at large? And how do you think this trend will affect the career pathways of future lawyers who seek to practice this specialty? I mean, you touched on this already, and we're skeptical that it would have that it would put you out of work at any rate. So let me come back to you for a quick update to that, if any.
Yeah, no, I was updating the panelists before we began our conversation that I have a younger brother. He's 20 years old. And the question he had for me last night was, are you afraid that AI is going to take over your job? And so quickly I retorted back, absolutely not. The work that we do is so complex in nature, and it's so it's ever changing every day. And so the way it moves and the way it grows, I don't think AI has the capacity to match that. I think an issue that we're seeing within the court system, within the civil courts and the federal courts, is the use of AI and disclosure of AI. So that's a ruling from the courts now, and there's been guidance on how AI can be used and the need to disclose the use of AI. Every time I've used AI, it is wrong. It has never given me the correct answer because I understand the law and how it applies. I can see the mistakes that AI makes. On the surface level, it seems like it's the right answer. It makes sense logically, but unfortunately, it is not correct in the law because there are a multitude of rules that may need to apply to any given circumstance. And so AI will never be able to comprehend all the layers and complexities of the law at its state right now. And I really think the human application and interpretation is so important, so critical. And so honestly, I'm really confident about the role of AI in this industry. I can see it having some sort of technical application. It can be used as a tool, perhaps to narrow down more technical administrative things. But in terms of the actual use and knowledge of the law, I don't think AI would ever be able to even keep up, candidly.
Thanks, Hannah. And to you, John, for a quick response.
Yeah, just I agree. For someone in Anu's position or my position, we've been able to develop judgment through years of practice and getting up that steep learning curve I mentioned before. We're still in transition with AI, and it's really hard to predict what's going to happen next. I think we're in this transitionary phase as we all are adopting it and adopting these tools. My biggest fear is that, I spoke earlier about the importance of, and I think Anu mentioned this as well, you don't get a lot of this training in law school, the importance as a young lawyer of being exposed to these files, doing the basic research, understanding the fundamentals of trade law and where it comes from and sources, et cetera. I think we're going to lose that with AI. And I do think young lawyers, to prepare for that, are going to have to understand how to use these tools. And I'll just give you a really quick example. A few weeks back, I wanted to understand an issue about US sanctions law that I didn't know off the top of my head. I fed it into our AI tools here. In 5 minutes, I had a detailed memorandum on the issue that would have, in the past would be a week, waiting for a week for that from a student. Or a young associate, and I checked through, and it was correct. There wasn't any incorrect statement in that memo, and so my fear is a lot of the lawyers in this space are going to be relying more on these prediction models or learning these AI tools without using younger lawyers. And I think younger lawyers can best protect against that by understanding themselves how to use this tool and being really flexible in these early years in your practice and responsive when it comes to dealing with this, because I think there's a real threat there.
Okay, thanks, John. We're going to close in just a minute. Valerie, do you have anything you want to add on that AI question? Okay. Well, listen, I didn't get to all the questions. There was a question about working in the policy space as well as a question about what are the regional centers for trade law. It's by anonymous attendee. Anonymous attendee, if you want to pose that question to me by email, I'll see if I can gather some responses and get back to you. But let me thank everybody for for asking the questions. And, you know, I have to say, and Hannah's going to close and thank our speakers properly, but I'm sure everyone was interested to see whether the decision on Trump's tariffs had come down from the U.S. Supreme Court. So I just want to personally also thank you for taking the time, but I'll turn it over to Hannah to properly close us.
Yeah, thank you so much for joining us today. We couldn't have asked for a better, more esteemed panel to speak on this issue. So thank you so much for engaging with us in real time on issues that are impacting all of us, and certainly explaining them to those who are particularly interested in the bright minds of the field. So thank you so much, everybody.
Thank you for the invitation.
Thank you.
Yeah.